Normally, I wouldn't resort to reading a bio blurb, but Tara's background is so extensive and diverse that I have no choice. She is a bona fide world-class authority in privacy and intellectual property issues. And just let me give you the thumbnail sketch here. Tara's a founding partner of the law firm of Aaron Sanders in Berry Hill here in Middle Tennessee. Her practice focuses on trademark, copyright, licensing, and privacy consultation for software companies, manufacturers, service providers, and creatives. Her clients include software firms, pharmaceutical and healthcare companies. From startups to public corporations, Tara has been awarded by Super Lawyers and Best Lawyer multiple times, and in 2016 was the USA Trademark Lawyer of the Year in the Lawyer Monthly 2016 Women in Law Awards. She's a certified information privacy professional in the United States, privacy law by the International Association of Privacy Professionals. She's an international speaker on issues relating to U.S. intellectual property, teaching U.S. copyright law at the University of Dresden every summer. It sounds like a good gig.
Cool.
She's been published by Oxford University Press and the Trademark Reporter. She's the chair of the Copyright Society of the South, and she recently served on a blockchain committee with the Nashville Technology Council to help steer the new Tennessee blockchain legislation, and was poorly quoted, or perhaps misquoted, in The Verge about that work. Tara, thanks for coming.
Absolutely.
Look forward to hearing what you have to say.
Thank you.
Thanks.
So how many people are here today because they've heard nightmares about this GDPR legislation? Okay. How many people are here because they're sick to death of getting all the privacy notices from companies that have started coming in since April? Okay. And how many people are just here for the lunch? Okay, all right, that's fair, that's fair. So, I'm pretty much here today to talk to the first group. My heart goes out to the people who are experiencing this from the consumer side and being flooded with all the new privacy notices that none of you are reading and that are being completely ineffective in terms of complying with GDPR. But I'm worried about the people who need to think about actually complying with it, the companies that are collecting data from individuals who are inside the European Union. It's been, this kind of felt like it came out of nowhere. It went into effect May 25th, 2018. There were discussions about it going on in the EU that nobody on this side of the pond was paying any attention to until about January, and we didn't get the final text until the end of March. So it's been a really quick process. If you haven't even started thinking about it yet, don't worry about it. About 80% of the companies in the United States haven't started thinking about it yet, but now is a really good time. So that's my intro. Let me grab my thing and try not to stand completely in front of my slides here. So the GDPR stands for the General Data Protection Regulation. You have seen this in the context of a lot of new privacy notices, but the P in GDPR doesn't stand for privacy, and it stands for data protection. I'm going to use data protection and privacy interchangeably in this discussion. There's a lot of criticism about the GDPR that it simply doesn't do what it was intended to do in terms of enhancing the privacy of EU citizens. And that it's way too interested in the weeds of protecting little pieces of personal data. I'm going to go ahead and throw that criticism out, and you all can decide what you think about that as we go through this. But what we're really talking about here is data protection. And we're going to talk about this primarily from the perspective of US companies, or in general non-EU companies, because the obligations are a little bit different if you're in the EU or not. But one of the things that's been really challenging for US companies is to get their heads around the fact that there is in fact this EU regulation that US companies have to comply with. But here we are. This has been a long time coming. As I said, they've been talking about GDPR kind of since about 2016, but pretty much since the beginning of computers. Europe and the world in general has been dealing with privacy in different ways. And obviously, as technology has been accelerating, the different laws and regulations that have come through have been more and more. This is not just happening in the EU, it's happening in other territories, and it's beginning to happen in the US. So we're sort of there now. But what I think is really interesting about this is the gaps between how well the laws have actually, or the laws of the regulations have actually dealt with the rise of technology and the acceleration of technology. It seems like it's getting better. We'll see. The reason this came out of the EU is that privacy is absolutely fundamental. I won't spend a lot of time with this on this, but privacy is absolutely fundamental in the EU. It is expressed in the Universal Declaration of Human Rights and in the European Convention on Human Rights, that they have the right to privacy in their home and particularly the right to privacy of their personal data. We don't have anything like that in the Constitution. We have sort of a patchwork of privacy that we glean out of the Fourth Amendment and the Fifth Amendment, but it is absolutely fundamental in the EU. All right, we'll get into the fundamental message, I think, that the GDPR is trying to get across is that as new technologies are being developed, as new platforms are coming online, as new businesses are coming online that are going to be collecting data from their customers, that privacy needs to be first and foremost in their thought process as they're developing their security system, as they're developing their workflow, that at all times you need to know where your data is and how you can access it. So there's a big push in the regulation about privacy by design. It requires that all organizations implement technical and organizational measures at the time of development to ensure data is safeguarded. So if you're a new company, if you're in the EC and you're just starting out, start thinking about this as you're building your company. If you're more established, now is still a good time. The other thing about thinking about privacy at the outset is not only developing those procedures, but documenting them. The other primary concern about GDPR is not only that the organization be secure, but that those security protocols are documented. They're always accountable. That's the really scary part about this regulation for a lot of companies is this sort of not real well-defined system in terms of how it's going to work in the US yet, but this idea that there are these supervisory authorities that we'll talk about a little bit more in the EU that some customer of yours who happens to be in France is going to complain to because you didn't follow the regulations, and then suddenly you're going to have to produce all these documentations to show that you were trying to comply with it in order to sort of avoid all these really scary remedies. So that's the nightmare scenario here. But so as you are developing your security protocols, documenting them, having internal policies that are well documented and well communicated to your staff is going to be really important. Privacy by design, for certainly in the IT world, isn't a new phrase. It's always been best practices to do that, but this is the first time that there have been remedies attached to non-compliance. So we're paying a lot more attention to it now. So this is GDPR in a nutshell. And we'll talk about each one of these 6 sort of highlights in a little bit more detail. Data processing must be lawful. It must be limited to the purpose for which it's needed. It must be accurate and must be kept up to date. It has to be secure, and the purpose for which it was collected has to be legitimate and clearly explained. Your data subjects, which include anyone who is in the EU. We don't quite know yet whether that means simply EU citizens or whether it means people who are passing through the EU. There are a lot of ambiguities in the language like that. So, but anyone who is in the EU and whom you are collecting information in order to provide them goods or services, whether or not they're paying for it. So it doesn't matter if it's free services. If you're providing them goods or services, which includes information or access to your platform, or if you are tracking their behavior in the EU for behavioral advertising reasons, for example, this is going to apply. So that's who a data subject is, and they have rights with respect to their data. It includes the right to access their data without cost. It includes the right to have their data corrected. There's this right to be forgotten that you've probably heard a lot about. There's the right of portability, and they have the right to object to the data being processed. The right of erasure and the right of objection are kind of limited. They're not maybe not quite as scary as they've made out to be in the press, but we'll talk about those a little bit more. We'll talk about the difference between data controllers and data processors. You can be either one, some of you might even be both, and what those obligations are in terms of security and accountability. We'll talk about the challenges that we're facing that are about to get worse in terms of data being transferred over the border from the EU to the US. And we'll talk about these nebulous supervisory authorities and how bad these remedies can actually get. So if I've made this all sound like doom and gloom, then I'm doing my job. Data processing. Processing of data basically means any form of touching a EU person's data. If you collect it voluntarily or automatically, if you store it, if it moves through your system, if you use it for any kind of advertising, any kind of touching of data is processing of data. Data processing has to be lawful. It has to be for legitimate purposes. It has to be limited, has to be accurate, has to be erased if it's no longer necessary. It has to be secure, and you are subject to accountability. These are the general sort of principles of data security under the GDPR. The place where we've probably spent the most time talking about GDPR is what those lawful bases, what it means to say that data processing must be lawful. There are 6 bases under the GDPR under which you can collect information or you can process data from data subjects. Depending on which ground you are working under, the data subject's rights change. We'll talk about that a little bit more. But the one that's probably been affecting you all so much so far is the informed consent ground, because that's where a lot of companies are basing their processing of data. That's why you're getting all of these emails that say, we've updated our privacy policy, please read it, and please opt in to accept. Because informed consent basically kills the whole idea of opting out. It is all opt-in now. Which means that a lot of companies we had to do the same thing. We have a blog, we collect information from the people who read our blog. We had to ask for permission to continue to read the blog. We have to just hope that the people actually read the email, click on the button, and send it back to us. So there's going to be a lot of friction there, and I think a lot of lost eyeballs for a lot of people, unfortunately. The good news is it's not the only way that you can collect information, though. Let me make sure I've got all my notes here on informed consent. Informed consent means consent for each type of processing. So if you are collecting information in order to provide a photography platform for customers, but you also want to know where they're taking those photographs so that you can give them tracked advertising or location-based advertising, you have to have two different consents for that. One for the collection of the information and the other for using it for behavioral tracking. One of the challenges is going to be figuring out when those are really 2 different activities and when they're not. But people are not so much putting these all into one big privacy policy at the bottom of the page, but actually putting pop-up blocks, at various places where their consumers interact with the websites now or interact with the platforms in order to get this consent. Checkboxes are good for consent as long as you can demonstrate that that consent was informed. So a checkbox that says, please read our highlighted privacy policy isn't going to be enough. A checkbox that has bullet points about what that privacy policy says probably is going to be enough. But if You don't want to go through that whole mess with consent, which, by the way, is almost always revocable by your subject. So if your ground for processing their data is consent, they can tell you to stop at any point. If you are providing paid services, then you probably have a contract. That's much better. It's much better to have a contract with these people. So if you're a subscription-based platform, if you're a academic journal, newsletter that that is paid, if you're in market research and you've paid for information, then you've got a contract, and that's a much more clear-cut and irrevocable way of having a lawful basis for processing the data. So those first two are probably going to be the ones that implicate private companies in the U.S. the most. You can process information if you have to comply with legal obligations. That's probably going to be a fairly rare occurrence. Basically, if there's been some lawsuit that involves people in the EU and you have to keep it for discovery purposes, fine. If it's for the purpose of protecting someone's interest, and that's the interest of an individual, not the interest of a company. If it's for the public interest, and then there's this last category of the legitimate interest of the processor. And I had a really interesting Twitter fight about about 2 months ago with the data governance officer for the New York Times, who was convinced that everything that they did in terms of processing data could be done under this legitimate interest basis, and that they were essentially using it as a catch-all, that, well, you know, it's fine, we don't have consent, it's fine, this is within our interests, so it's okay. That is not how this is that's not how this is gonna play out, because the whole push behind the GDPR was to give data subjects meaningful rights to their data, the meaningful ability to control how their data is being used. And if it's all wiped away by this legitimate interest exception, then it's obviously not meeting its goal. And the supervisory authorities in the GDPR just aren't, in the EU just are not going to put up with that. So if you, for whatever reason, can't get consent and you don't have a contract, then we'll have to think hard about what those legitimate interests are, because I don't think you can just sort of drop down to that and move on. The New York Times data governance officer thinks you can, so you can decide which one of us you want to believe. I think so. If it's for ongoing services. So if you are selling widgets and a person buys one from you, that doesn't give you carte blanche to use their data for any other purpose. But if you are giving them ongoing services, whether they paid once or whether it's through some sort of a monthly subscription, if you have an obligation because of that payment to provide services, then you've still got a contract. So in that case, and we'll talk about, well, actually we can talk about it now. If you're talking there about your doctor is going to be the data processor, right? Because, or no, actually, I'm sorry, he's going to be the data controller. He's going to be the one who is actually collecting the information. So yes, he's going to have to get consent from the patients, although I'm guessing that healthcare in France isn't all that much different in terms of, it might even be more strict than what HIPAA rules are here. My guess is that they probably already get that kind of consent. It might be that the forms have to change in terms of how much they have to identify about where that data is going, but that's going to be on the doctors or on the hospital to do. And then their relationship with their portal provider, their service provider, that's going to be where this really affects things, and we'll get to that if you don't mind. So, lawful basis for processing data. Rights of the data subject. So they have quite a few rights, actually. They have the right to know who is processing their information. So in your example, they have the right to know not only that the hospital has access to their data, but which portals they're giving it to, or where it's being stored. They have the right to access of the data, and you can't charge them for it. You can charge them, they can pay the cost, I guess I should have said fee-free, but they can pay, sort of the postage cost of sending them the data. You're probably going to email it to them anyway, but you can't sort of turn that into a profit center. They have the right to have their information corrected, which is probably in your best interest anyway. They have the right to be forgotten. It's a limited right. It doesn't apply to all bases, and it doesn't apply to all kinds of data. And it is always going to come up against the company's business interests. So, for example, if they participated in a survey and you took their data and everyone else's, anonymized it, aggregated it, and sent it out for market research, you don't have to go extract their information from those reports. One thing that is really sort of keeping the U.S. lawyers up at night is how this is going to play in terms of litigation in the U.S. So if your company gets sued, the first thing that your lawyer sends you is a litigation hold letter, which means don't destroy anything, right? Even if you have sort of a data destruction policy, keep everything, because otherwise it's going to look like you've spoiled the evidence and then we're going to be in a whole bunch of trouble. If you are in a litigation hold and you get a erasure request from a data subject in the EU, what do? We don't know yet. But if they're, again, this is limited to certain bases of processing. So if it's based on consent, they can always revoke that consent. They can ask that their information be erased. If you are collecting information solely for the purpose of marketing, they can ask that their information be erased. And also, I'm trying not to get too down in the weeds here because we don't have a ton of time, and I want to make sure that there's time for questions. If you're collecting special categories of data, so, and this really applies in the market research field, if you're collecting political opinions or religious beliefs, or if you're collecting racial information or sexual orientation information, all of that is considered a special category, and they can always ask that that information be erased. And it does mean erased, right? It doesn't mean, sort of archived or stored, in a different silo. It means erased. They can ask to have their data ported, which I didn't really think sounded like that big of a deal, but the IT people in the world think that it is, and the business people in the world think that it is, especially because what that could mean is sending the data that you've collected on somebody to a competitor, because it doesn't just mean having the data sent to them, it means having it sent to some third party, and it's whatever third party that they want. And it has to be in a commercially reasonable format and all of that. And they can object to certain kind of processing, but really that's kind of if you did the processing without worrying about the lawful basis in the first place. So those are their rights. This is one of those places where the GDPR is not clear at all. It talks about expenses, but we don't know what that just means. What are the expenses associated with that other than the time of your staff to go in and do that? I mean, is it? Okay, so, and I think that's one of those areas where you're going to be able to say that that the company has a legitimate business interest in not deleting the data because it's going to screw with the integrity of the system. I think that's absolutely going to be fair. I don't know that. We haven't seen the case yet, and the GDPR is not clear on that. I think they tried to draft this thing, so that it could cover all situations, and they made it too vague to be really useful. Also, it was originally written in French, and I'm reading the translation, so, this could be all wrong, I don't know. So this gets back to your question on the controllers and the processors. So they're two different groups. They've got slightly different responsibilities. Controllers are the frontline folks who collect the data, who decide what data is going to be collected. They're responsible for implementing appropriate technical and organizational measures to implement all of the GDPR, essentially. And then processors are those who process data on behalf of the controllers. So a lot of the first clients who came to me about this were e-commerce platforms who had clients who were operating, let's say, a cheese shop in France, where their consumers were in France or in Germany or whatever, wherever. They were ordering cheese online, and the transaction was going through my client's platform. Like they operated the shopping cart kind of thing. So they're pretty clearly a data processor. They're touching the data as it comes through their system. The cheese shop in France is the data controller. The purchasers in Germany are the data subjects. So, yes. Oh, God, that was fast. Shoot, okay. So, I could probably talk for 10 or 15 minutes about data representatives and data protection officers. Processors or controllers who are not in the EU are required. The first line of the regulation is that they're required to have a data representative in the EU. Kind of like you would have, if you started an LLC, you'd have a registered agent when you start your corporation, except that your data representative has a whole lot more obligations than that under the EU. However, the next line of the GDPR is that this only applies if your, or this does not apply, excuse me, if your processing is occasional, if it doesn't affect large percentages of the population, and if it would not, if the lack of having a representative would not weaken the rights of the data subject or affect them negatively. I don't know what that means. I don't know what occasionally means. I have no idea. I think that if your population of customers is less than, let's say, 50%, then maybe you don't need this. Maybe it's less than 30%. It may be, so in an earlier draft of the GDPR, it said if you were processing less than 50,000 records. So if your customer base is smaller than that, maybe you don't need that. If it's around there, you probably do. We are having a hard time finding an organization that we trust to be a data representative. This is all very new. This is a huge market for consultants in the EU, right? This is going to be a huge profit center for consultants in the EU. They're trying to figure out how to price it. So there's that. Also, if you are in the business of processing data, and it's not sort of incidental to your business, you probably need a data protection officer, which is somebody either in-house or somebody that you can hire locally. It doesn't have to be in the EU to sort of be your consultant and be your contact for data subjects who want to complain about this. I can answer a lot more questions about that. But both controllers and processors are responsible for making sure that the data is secure, which may include encryption but doesn't have to. They also have to have disaster and breach response plans, which you should have anyway because there are a lot of countries or states in the US that are requiring that. And for the most part, if your data is encrypted, you don't have to comply with all the data breach laws as much. So you don't have to notify all the consumers if the data that was breached was encrypted, which cuts down on your cost in a data breach situation considerably. So if it's possible to do that, it's probably a good idea. Okay, we'll get to cross-border transfers for sure. So as I said, a lot of my clients are, say, e-commerce who are data processors in the US. Their controllers and their data subjects, obviously, are in the EU. That data is being transferred from the EU to the US. This has been something that has been problematic for a number of years because basically the EU doesn't trust the US. They don't think that our privacy regulations are adequate. Our privacy regulations are a patchwork. In some places they're adequate, in some places they're not. I think it's really interesting that London has more CCTV cameras than any place else in the world, but they're complaining about our privacy regulations. But so there was a provision called Safe Harbor that companies could comply with that meant that they were, if they complied with certain obligations, then they wouldn't have liability for having data transferred to them in the EU. That went away. We now have Privacy Shield, and we have what are called in the GDPR standard contractual clauses. Basically, if you are processing data in the EU for controllers, or sorry, if you're processing data in the US for controllers in the EU, what you need is a data protection agreement between you and your controller. It's a simple agreement because the EU has written it for us. It basically says that the processors in the US promise to comply with the relevant provisions of the GDPR and includes certain parts of their security protocol written out to prove that they actually comply with that. It's not complicated. A lot of what my clients are doing, particularly if they're in kind of the retail space and they have, especially if their customers who are controllers can just subscribe to the services online, is they'll just put it on their website and they'll put it in like Hello Doc or whatever, and they'll say, look, here it is. If you need it, you can have it, you can sign it, and that's fine. So it's not a big deal. The problem is that those contractual clauses and also Privacy Shield are both under review in the EU, and it doesn't look good for either one of them. So Privacy Shield is going under review with the EU Parliament in October. But there was a resolution passed that said that it should be done away with. It was a resolution, which doesn't really mean anything, but it means the majority of the MEPs in the EU think that we should do away with Privacy Shield. The standard contractual clauses are being challenged in an Irish court case. And the big problem is that the EU does not think that our privacy regulations, regardless of how well we comply with either one of these things, will protect us when the US government comes for information. After the scandals with Facebook cooperating with the US government and the Edward Snowden and everything else, it's basically the feds that the EU doesn't trust. So, and I don't think those are going to change anytime soon, so I don't think either one of these things are going to stand up. And then the question is really going to become, under what mechanism can we transfer that information from the EU to the US, and can we? We'll see. So, let's see, because I want to make sure I have time. Okay, this is going to be really quick, and then we'll get to like the useful information and not just the stuff that scares you. Okay, so every member state, of which there are right now 28, probably soon to be 27, have their own supervisory authorities. It's going to be really interesting to know, and they're the ones who are basically in charge of administering a complaint if a data subject files one. They file in their own country. It's going to be really interesting to know which country has jurisdiction, so to speak, over a US company that has customers in all 27, 28 member states. We'll see. Yeah, so that's another one of those big questions. The remedies, so we haven't obviously seen anything like this yet, and these are addressed to the Facebooks and the Googles, right? They're not addressed to you guys. But the maximum is 4% of global revenue, which is why people are sitting up and paying attention to this. One other really big question is how this is actually going to get enforced against US companies. The way it normally works is if a US company breaks the law in France, the case goes to court in France. There's a judgment against the company entered in France, and then it comes to the US for enforcement, basically to collect the money. But it has to be approved by a US court. US courts generally give foreign judgments what we call full faith and credit, but only if those judgments only if those judgments comport with U.S. public policy, essentially. If there's some major conflict between, let's say it conflicts against the First Amendment, they're not going to give it full faith and credit, and they're not going to enforce it in the U.S. I think it will depend very much on exactly what the non-compliance issue in this was, as to whether or not a U.S. court is going to give it full faith and credit. And so I think a lot of people are just saying, well, no court in the U.S. is ever going to enforce this, so why do I even need to bother? This is coming to the U.S. California just passed a fairly similar law just in June that's going to go into effect in early 2020. It's not quite as onerous as the GDPR, and it makes it much more clear who has to comply with it, and I think it is over 50,000 customer records. But those are Californian customer records, which you're much more likely to have than you are in Europe, probably, maybe. And right now, and it's very possible that the law is going to get kind of tweaked before it goes into effect in 2020, but right now there's this great provision in it that says that when you log into Facebook on January 2nd, there's going to have to be this box on the screen that says, "Do not sell my information," that you can click, and that Facebook will mean that Facebook can no longer sell your information and can't not give you services just because you've told them not to sell your information. Which may be great for Facebook, but that would literally apply to every company collecting more than 50,000 records from a California. I mean, literally a box on the screen, right? So we'll see whether or not that stays in the law. But states are taking drastic measures on privacy. And the thing about that in California is that if that stays, and Californians are now are free from having their data sold by Facebook, you know, Nevada people are going to start knocking on the doors of their legislatures, and it's going to come east, right? So we're going to see this. We're going to see these kinds of provisions, and we're going to see them with fairly steep penalties coming across the U.S., so you might as well start paying attention to it now. So what should you do? The best thing you can do is to create a concise privacy notice, but the privacy notice should be created from, that should be sort of the last thing that happens. It has to reflect how your company is actually doing business, right? So don't pull a form privacy policy up and put it up. It's always been true in the US that you can't lie about what your privacy policy says. Whatever it says has to be the way you actually do business. So don't just pull a form offline. Figure out where your information is, how quickly you can access it, how well you can comply with any requests from a data subject, and then put that in your privacy policy. And I can make these available, so you guys don't have to worry about writing this down. But you know, there are 10 questions that need to be answered, and then those go into your external privacy notice. So you create the notice, you notify your customers, you comply with the privacy notice, you make sure your entire team is complying with the privacy notice, you update the privacy notice as it needs to be done depending on how your company does business, and you comply with it. And that is essentially the best thing that you can do right now. I am certainly available to help. This is what I do. But I promise you, I'm not just going to sort of, you know, hand you a form document. We're going to talk through this process and what these notices have to say and what your policies should look like on the back end. And we will continue to sort of watch how this plays out in Europe, how it plays out against US companies in Europe, and how the US responds and how the US makes laws that look like this. I think for a long time we're going to end up with a patchwork of US privacy laws, but sooner or later we'll get a federal system, and so there'll just be one thing, and then, you know, I'll be out of a job. But for now, I'm here to help. So, questions? Yes, have a good privacy policy, right? Always, like regardless of whether this is even a thing, have a good privacy policy. If it's just that your website is open to the EU, so the definition of personal data includes IP addresses. But if they're just coming to you and you're not collecting anything more than that, I mean, you certainly don't need a a EU representative. I think it's still a good idea to know where your data is, because it's not a huge cost for a company to know how they could respond to these requests from data subjects if they had to. For the most part, it's not. But if you can just have that as part of your best practices, then I don't think you have to lose sleep over this right now. Does that answer your question?
Would like to thank Tara for sharing her expertise. Please. Thank you. And thank you all for coming. Have a great day.